Hello, good evening. Am I audible? Yuvraj?
Yes, sir. Good evening, sir.
Okay, okay. Thank you, thank you. Dr. Sneha, welcome. Good evening.
Good evening. Am I audible?
Audio, audio. Yes, yes, yes. Welcome, welcome.
Okay. Namaste.
Namaste. Thank you for joining. So we'll be
Yes,
starting
yes.
maybe 6:30 or people are joining.
No issues.
Okay.
Good evening, ma'am. Can I start the session?
Yes, you can.
Okay. Good evening, everyone. I am Yuvraj Singh, a first-year law student at IILM University. As a moderator, I welcome you all to the 8th day of this 5th edition term course on legal aid and allied laws organized by Pro Bono India in collaboration with Pro Bono Club, GNLU Gandhinagar. Access to justice is a fundamental right, and India has taken significant strides in promoting inclusivity and equality through various initiatives. Today, we will explore the key initiatives undertaken by the Indian government to strengthen access to justice, particularly through DISA scheme and other notable programs. It is my pleasure to introduce our esteemed guest, Dr. Sneha ma'am. She is a renowned expert in the field of women and child rights. With an impressive renowned expert in the field of women and child rights, with an impressive academic background, including a PhD from CNLU Patna and an LLM in intellectual property law from Nalasar, Hyderabad. Dr. Sneha has made significant contributions to the field. She has held various leadership roles, including director programs at Center Direct and assistant professor at Indore Institute of Law. Currently, Dr. Sneha serves as program manager at the Department of Justice, where she oversees the implementation of the Access to Justice program at a pan-India level. We are honored to have Dr. Sneha ma'am to share her insights with us. With this, I would like to hand over the session to ma'am. Ma'am, please.
Thank you so much. And you have said so many things about me. So it is not true that I'm a renowned person. No, not at all. We all are learning. We are learning, from each other. So in today's lecture, I'll be showing one PPT. So I'm just sharing that. Is it visible?
Yes, ma'am, it is visible.
Okay. So the topic which I have chosen for today's lecture is about access to justice, ecosystem, and the initiatives of Government of India. To begin with, let me give you a brief sort of introduction that Ministry of Law and Justice is divided into three departments: Department of Justice, Department of Legal Affairs, and Legislative Department. And every department has their own business allocation. So the Legislative Department is the department responsible for the drafting of bills, which become the law, which we see the enactment, the statutes. Well, Department of Legal Affairs is responsible for the maintenance of your Advocates Act and many such acts. Plus, your advocates also come under their purview. Department of Justice have different divisions where it starts from appointment of judges, coming to the e-courts, coming down to the infrastructure, coming down to the fast track court mechanism, then coming down to the division from where I'm representing Ministry of Law and Justice is Access to Justice Division, where Access to Justice Division have different programs or scheme running under that. So to begin with, the word which we are calling and the session is all about equal justice and free legal aid. So, what is the genesis of this equal justice and free legal aid? Part 4 of the Constitution of India, we have Article 39A, which states the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justices are not denied to any citizen by reason of economic or other disabilities. So when you read the Article 39A in toto, so you can highlight two important words that how state will secure to provide free legal aid by two mechanism. You can see the two important words in the whole article. The first word is legislation. The second word is schemes. Legislation or schemes. So legislation have given the genesis of your Legal Services Authorities Act 1987, the whole ecosystem of NALSA, which promotes access to justice for all. Under that, you have Section 12 category, where they provide free legal aid to the people falling under that particular category. NALSA is the body at center. Simultaneously, they have the representation at state level, at district level, at taluk level. In the orientation program, you have witnessed the member secretary of DLSA. So that is the third wing, if you can see. The NALSA, under that SALSA, under that DALSA, and then TALSA. So this is the hierarchy, and this is the system, which is, I will not say, sorry, hierarchy. It is the enforcement mechanism system, justice delivery mechanism system, where the representation is at every level. If we take it from the ground, it is at taluk level, then district level, then state level, then at central level. So everyone is aware about NALSA. Somewhere or the other, you must have read in your books, even in your ADR chapter, in your ADR course, you must be reading about NALSA, LSA Act, ADR mechanism, Lok Adalat. But no one talks about the word, there is a scheme word mentioned in the article. So from scheme word, Department of Justice, Ministry of Law and Justice have created one scheme named as DISHA. So DISHA stands for Designing Innovative Solutions for Holistic Access to Justice in India. So these are the two important things you people can write down also. So Article 39A is the mother of these two important programs in India, where one program is running under the statute, the other programs are running under the scheme. So NALSA is the body. Under that, you have the provision of SALSA, you have the provision of DALSA and TALSA. Under scheme, you have the DISHA scheme. Now, coming to the Indian experience, because today I'm not giving you any theoretical knowledge, because already you read it or you learn it or you are being taught by your course teacher in your regular classes. So today I'm going to give you some practical aspects and what are the initiatives or what are the things which are being done at pan-India level. So coming to the Indian experience, we have entered 2025. Okay, the generation are also called as Gen Z and Alpha, Beta, Gamma. Some sort of name is being given to the generation who are getting born in this particular area. So everything somewhere or the other is not technology driven. And we are also aspiring, because very soon we have entered 75th years of India being republic, and we have celebrated the 75th anniversary of the adoption of our Constitution of India. So in 2047, India will be at 100th year of its independence. And what we are aiming, what is our vision for 2047, what we are aiming, that how India will look, the justice ecosystem, how justice ecosystem will look like in 2047. So before taking you there, let me give you a glimpses that what we will talk today. We will talk that in a particular ecosystem, justice ecosystem, you have two stages. The first stage is pre-litigation intervention. What we are doing under pre-litigation interventions, you people are aware of the term ADR, that is alternative dispute resolution mechanism, and under that you have different modes of doing that ADR. You have arbitration, you have mediation, you have conciliation, you have Lok Adalat, the setup of Lok Adalat, which is also in different forms. There is a permanent Lok Adalat, there is a mobile Lok Adalat. So there are forms. And today...
Excuse me, ma'am.
Yeah.
Sorry to interrupt, ma'am. Ma'am, your slide is not changing.
So it's a first slide only?
Yes, ma'am.
What is now?
No, ma'am.
Now? No?
No, ma'am. Can you share it again? And yes, ma'am. Yes, ma'am. It is visible.
Yeah, it's changed.
Now it is perfect.
So is it in slideshow mode or not? Is it in slideshow mode?
Yes, ma'am. Yes, ma'am.
No slideshow mode. No.
Right
Slideshow
now?
में नहीं है.
Because अभी मैंने slideshow किया है इसको.
अभी नॉर्मली है, पीडीएफ है, नॉट स्लाइड शो मोड.
Wait, I'm doing it again.
Yeah, sure, sure.
Is it visible?
Yes, ma'am.
Okay. So, are you able to see the three components: post litigation, pre litigation, and whole of government approach?
Yes,
Yes,
ma'am.
yes.
Okay, okay. So, under pre litigation intervention, as I was talking about, that we have ADR mechanism. So, there are important stages of dispute resolution. We need to do the promotion of right based informed citizens. And Government of India, under Disha scheme, has launched telelaw program. So it is a unique experiment where what we are doing, we are providing pre-litigation advice to the citizens. We have Nyay Bandhu program where we are providing pro bono services to the litigants. Then we have Lok Adalat and then NALSA. So these all are the component which we can say are pre-litigation intervention. Then coming to the word post-litigation intervention. Under that, you have holistic digitization of judicial delivery system. You have e-courts project in India, which aims to enhance judicial productivity, making justice delivery system accessible, cost effective, reliable, and transparent. Then coming down to the whole of government approach. Promotion of digital public infrastructure. Your Jandhan, Aadhaar, mobile, UPI. Ecosystem approach for integrated citizen services. Now, we all have witnessed, we all have, experienced COVID era. In that COVID era, and thanks to that COVID era, that today we are having this, interaction over WebEx. Because COVID has taught us that distance does not matter. If your intentions are good, you will you will try to connect and you will create such ecosystem. So where digital intervention, your technology intervention have created a platform where people can talk, people can deliver lecture, people can interact, and people can share their knowledge through a mode, right? Today, you people are sitting at different parts of the world but connected. Now, this whole thing which we see that today in everyone's phone, at least the audience which are having this webinar today, this guest lecture today, must be having Android phone with them. And every day you people must be transacting minimum of 100 rupees from your UPI mode, right? Whether it is Paytm, Phone Pay, Google Pay, where you go to buy milk, vegetable, or you buy a samosa, you buy a poha, or anything. You travel, you give to auto rickshaw wala, or any sort of thing which you do in your entire day. This UPI is has created a revolution. Let me tell you, a technology revolution. Likewise, we are aiming in the justice ecosystem that there should be a digital revolution. And yes, we have witnessed that. The virtual court hearings, the e-court mechanism are proving that citizens do not need to, spend money for, court appearances. The system is now transparent. You can hear Supreme Court hearings live, right? So the system is being, because e-court has project is also rolled out in India in phase manner, phase 1, phase 2, phase 3. In phase manner, what we did, we started with the LAN connectivity, then we went to WAN connectivity, and now it's 4G, 5G. So the internet connectivity are being established. Courts are being digitized, court records are being getting digitized, not 100%, I will tell you, but there is a step in doing that, so that the information, because who is the king? King is the person who have the information. And the information regarding the judicial process, information regarding your own case, if you are a litigant and if you are having the case matter listed in the court, the citizen should be accessible to have that when the court is listed in the court, that the person should not, wasting time in moving to the court every now and then. So the system are getting placed. I am not telling you that it's a foolproof system right now, but yes, systems are getting placed in courts. Courts are, are being keeping in mind every form of disability free, where person can access that court whether in a digital form or whether if they are going physically. The whole process are, are trying to become a seamless, where a person can approach to the court. So these are the three things through which we are trying to, tell you about the Indian experience and how the technology has taken over to the holistic and equitable access to justice. Has the slide moved? Are you able to
Yes, yes.
see? Yeah?
Yes, yes.
Yeah. Okay. So coming to the first model where I was talking about the pre-litigation thing. So coming to the program, the telelaw program, what we are doing here, we are providing free legal advice to every citizen, irrespective of their category, whether they fall under section 12 or not, whether they are women, whether they are child, where their annual income is less than 1 lakh, we are not bothered. We are providing free legal advice. How we are doing that? We have 4 delivery models running currently in India. The first one is your grassroots network. What is this grassroots network? We have Common Service Center, CSC, in 2.5 lakh gram panchayats, where they are equipped with digital infrastructure. So they will have a, small room or maybe a big room, whatever you can, give that name. And it will look like maybe like a cyber cafe or maybe like a general store or kirana shop, where a person will be sitting with a system or a laptop, computer system or a laptop. And that person is known as VLE, village level entrepreneur, where that person will help the person coming to that particular store or shop or whatever, that if a person requires a legal advice, so the VLE, the person running that particular center or shop, will make the appointment of the beneficiary with a panel lawyer over a video conferencing call or over a telephonic call. So this is the thing where a person can directly visit to that particular center and get the appointment of the lawyer and can talk with the lawyer about their case. If there is a case at all, he can ask the query, he can get the information. We are empowering citizens with information if they want to know about any information. So this is the first delivery model where there is a physical intervention. Second model is your tech-based access. How we are doing that? We have enabled through mobile application. We have telelaw mobile application for citizens. One can go to the Play Store. They can download the mobile application with the name telelaw, and by themselves only they can, put their credentials, put their information, and they can get the appointment of the lawyer. They do not need a third person in, making that call or making that particular appointment thing, because if a person is having an Android phone, so we expect that person will be a bit tech literate and that person can book a slot for him or herself. The third model is your tele-facilitation center. It is an omni-access tele-facilitation for removing the barriers of technology, infrastructure, exclusion, and discrimination. The person having a keypad phone, if a person is not having a smartphone, he has a third option. He can dial the number 14454. Everyone can write this number and can, make people aware around you. that 14454 is the toll-free number of telelaw program where a person can get the advice, a person can get the counseling. If you want a counselor, you can also call on this number. The telecaller will take your call, and if tell him or her, whoever has taken your call, that I need a counselor because I need a counseling because I'm not feeling good. Or if there is a case of domestic violence, first I need a counseling. If there is a case of anxiety, mental stress at workplace or at college, I need to talk to a counselor. So those are the mechanism is in place as TFC, what we call in short, Telefacilitation Center. Coming to the fourth model, that is your doorstep delivery. Now, what is this doorstep delivery? So Niti Aayog has come up with the list of 112 aspirational districts and 500 aspirational blocks. Now, what is this aspirational district and aspirational blocks? There are indicators where it shows that particular district or particular block stand at what sort of parameter, or what sort of ranking in terms of development. The low ranking, or maybe no ranking district, places or block are known as aspirational district, as the case may be, or aspirational blocks. In Hindi, we call it Akanshit Jile or Akanshit block. Now, this Akanshit Jile in 112 district and in aspirational blocks, we have 500 aspirational blocks in India. And 500 aspirational blocks, we have positioned 500 Nyaya Sahayaks. Nyaya Sahayaks are the volunteers, or we can say the community messenger, who goes door to door and inform people that there is a program, there is a scheme under which you can get the legal advice. And the person himself or herself will make this connectivity. If the person visits the household of a X person, he goes there, that person might be living in a hut. He does not know what is the meaning of telephone. He does not know anything. So on the behalf of that particular person, on the behalf of that beneficiary, these community messengers or this Nyaya Sahayak will make the appointment on their own mobile application on the behalf of that beneficiary, and will get the call connected and make the person available with a panel lawyer, and he can discuss the case, or she can discuss the case or whatever thing he want to take advice upon. So these are the 4 delivery models. You can write it down. In a telelaw program, the first model is your VLE model. Second model is your mobile application. Third model is your toll-free number. Fourth model is the Nyaya Sahayak model. So these are the 4 delivery models running under telelaw program. Now, coming to the right side of my presentation, you can see there is a telelaw workflow. How we are doing it? Beneficiary may seek appointment with these 4 modules. They can have telelaw mobile app. They can visit CSC center. They can receive the appointment, or they can call directly 1454. They can consult with a lawyer with a video call or telephonic call. Legal advice is given and the beneficiary is served. Now, there is one more addition to it. Our second program is your Nyaya Bandhu Pro Bono Legal Services, where in the Nyaya Bandhu Pro Bono program, it is the first ever dispensation of pro bono service in the country. So if a person under telelaw program has got the information or the legal advice, but the case needs the representation in the court, then the same lawyer can direct his case to the Nyaya Bandhu lawyer, where the Nyaya Bandhu lawyer can give the pro bono services in the court. So here is the integration part. Telelaw is integrated with the Nyaya Bandhu program when the beneficiary needs a one step more beyond advice. So this is the model how we work under telelaw workflow. There were challenges because access barriers. We talk about, we are there in 2.5 lakh gram panchayats. There is a remote access through mobile app. We have 14454 number. But there is an access barrier because at every front, maybe person cannot go and visit a particular center. For that person, mobile app is a benefit for that particular person. Maybe that person is not having a smartphone at all. In that scenario, keypad phone is available with that person can dial 14454. Even though that is not the case, we have not doorstep delivery. At least we have started from, aspirational block area. So the person will come to your doorstep and give the counseling. And if you require any legal advice, you can get it assisted through that particular person. Coming to the discrimination and exclusion challenge, we now have that targeted approach to marginalized section. We have created the hotline number, and there we have specialist. The lawyer is specialized in all the corporate matters. Lawyer is specialized in dealing the cases related to human right violation. Lawyers are specialized in dealing with cases related to women and children. Lawyers are specialized to deal with the cases with elderly. Lawyers are specialists in dealing the cases with person with disability. So there we have trying to incorporate the, inclusion thing. Coming down to the language and cost, we are having the lawyers because the recruitment process starts with this particular criteria. Apart from BCI degree, BCI certification, apart from experiences, that particular person should be well versed in their local language. So we need, when you call or when you get the advice, their language should not be barrier. So this is the step which we are trying to do under telelaw program. Coming to the second program, that is Nyaya Bandhu Pro Bono Legal Services. As I already said you, it is India's first pro bono dispensation framework. And how we work, we have mobile application and web portal where we are connecting pro bono advocates with registered applicants. Here, there is a difference between telelaw and pro bono program. Here, pro bono program is available only to the Section 12 people who are under LSA Act. We have covered 8,000 plus advocates. We have rolled out pro bono club scheme in 109 law schools. We have created Nyaya Bandhu panel in 23 high courts. We are trying to inculcate the feeling of pro bono, and today also it is done. Pro bono India is doing really a very commendable job, and Mr. Kalpesh Gupta is really a pioneer in bringing this pro bono thing. Because earlier what used to happen, whenever anyone used to type pro bono, our website does not show. It is his website which pops up first. So that is the thing he has achieved. So but we are trying at the point of government of India is trying to bring up the dispensation framework. But still there are many factors where we need the policy change, we need the wherewithal, where we can see that the lawyers who are giving the advices are at least to get some support from our side, like the miscellaneous expenses or the photocopying or the travel expenses which they bear for the litigants. So the discussions are ongoing, and it is very difficult to pass anything to be mandated. But we are trying. That is a pro bono thing. It is a voluntary service. Lawyers should come up and register themselves for giving this pro bono services. So we are doing at the part of government of India whatever we can do right now in the best capacity. But let's see what future holds for pro bono thing in the country, because we really want that the best practices of South Asian countries, the best practices of USA, UK should be incorporated in India, where there should be minimum number of hours to be dedicated by the lawyers in doing the pro bono thing. So that thing we have at least tried in our pro bono clubs, where we expect that at least the law students, they are not the lawyers, but they can devote pro bono services in the form of community care legal assistance, in the form of pro bono legal assistance, or in the form of participating in the competition like client counseling, mediation competition. So we expect that from law schools. Now I will not take much of your time. Coming down directly to that, what we aimed at vision at the rate 2047. So we are trying to focus upon one nation, one judicial data grid, NJDG. We are we we aim that NJDG seamlessly, there should be one portal where there is a connectivity between a court, a police station, forensic lab, hospital, prison, revenue authorities. So one data should be available to all the stakeholders involved in that particular case. We are expecting that all India e-repository of cases record across all courts, integration of existing CIS with common grid, technology solutions for all verification and informations in court. We are expecting that there should be 100% digitized court process paperless. We are also hoping for integrated case management system. That is, there should be a timely disposal by adopting case management hearing for all cases along with case flow management using ICT. So this is the aim which we are aiming, that when India will be, at 100th years of their its independence, the whole justice delivery system should look in such manner. But obviously, coming up of AI, coming of technology does not mean that there is eradication of human, because we need the human touch, we need the human emotion while passing any judgment. We need the role of the lawyer to be, dealing with the case, even if how much technology comes up. Now, coming to the last slide of my presentation today. So, what we see that challenges and way forward. So the challenges today is inclusion. We want that there should be the last mile coverage. अंतिम पड़ाव पे जो इंसान खड़ा है, we should cover that person. Language and literacy barrier should be, eradicated. How? Because when we talk about, language, India has such a geography that in every 5 kilometers, language changes, dialect changes. You go to Northeast, there are different dialects there. So there are so many versions of thing that this is the, sort of challenges the Indians face. There is no English Hindi thing. There are dialects. There are different multiple regional languages in which we converse. There is a literacy barrier. Then when we talk about literacy barrier, obviously I will talk about accessibility, where there is a digital divide. There is a problem of awareness and trust. When I appeal to the law school, that there should be a continuous activity of, community care legal assistance in the adopted villages, because the stress is upon, if you go one time to that particular area, the person will not have the trust on you. Those innocent villagers will not have trust on you. They will not come up with the problem which they are facing. They will like, oh, they come and go, they do nothing. So you need to build that trust among that particular sector of the people. And when you become a lawyer, this is a very important tactics also, which you need to, undertake, that how you will gain confidence, trust of your client. Coming down to the accessibility, there's a digital divide. There will always be the question of have and have nots. There is a physical accessibility, there's a technological literacy. So accessibility issue is the main challenge. Coming down to the adaptability, there is always a resistance to change. Let me tell you, dear students, we are trying our level best to digitize our codes. We are trying to bring all the, electronic and digital intervention, but still the mindset of the people, whether it is lawyer, whether it is judges, still there is a mindset where people are resistant to change, not because they don't want to, because we are very comfortable in the present form. We do not want to change that. But how we can, change their mindset? By having this capacity building, by training them, at regular intervals, because people have the, lack of confidence, plus they think there is a privacy concern, there is a data security concern also, because if everything is online, there will be a chance of, the virus getting attacked, and there will be a malware, and there can be a many problem associated with digitization. So people have, sort of inhibitions before going to adopt any change. Now, coming down to the way forward, yes, we have innovations. Now we have AI based innovations for automation, ease of usage. We have PPP model, enabling framework for private participation to drive innovation. Knowledge, we need standards based open network for enabling seamless flow of information. And we cannot tell that Wikipedia is the only source right now where it gives the information, and that too in a bits, and because anybody can, have that thing to edit that. Coming to the technology part, we are trying to have the open source where people can, put in their information, people can, give their own sort of thinking. And we have this Hamara Samvidhan Hamara Samman portal, where student can go and contribute their things over that, contributes their, findings of constitution, their articles on Samvidhan Katta, or many things like that. Kindly visit the website. You can get the information about constitution, and you can participate in the various competition if the competition is ongoing. So this is the thing which I wanted to share today with you, that how at the Department of Justice or Ministry of Law and Justice we are taking it, and we are trying to build up many things. But what we can say कि जादू की छड़ी नहीं है हमारे पास, और वो जादू की छड़ी आपके पास है. हमने एक सिस्टम बना दिया. We have developed one system. We are coming up with the schemes and programs, but the problem is the lack of awareness. People are not knowing it. I am 100% sure the program which I have talked about today, maybe one or two might be knowing today. So this is, and if one and two are knowing, it is all because of Mr. Kalpesh Gupta. I'm 100% sure, because he has continuously in his all these sessions have included telelaw initiative in his PPT. So I know that it is all about what I believe, each one teach 10. If today you have learned anything, go and tell 10 people. Those 10 people will tell another 10 people. So there is a chain. At least at your part, at your position, you can impart the awareness. And at every session, I tell that whatever you have learned today in this session, kindly go back and talk with the lowest people in the strata of the society which you know. So those people can get the benefit of such scheme and programs, because until unless we all are at a failure, because the programs if are not being availed by the people is of no use. सरकारें में स्कीम आती हैं, चाहे वो सेंट्रल गवर्नमेंट हो चाहे स्टेट गवर्नमेंट हो, जब तक लोग नहीं जानते हैं इसका कोई मतलब नहीं है, बिकॉज ये सिटीजन्स के लिए है. इफ दे आर नॉट गोइंग टू द सिटीजन्स, it stands fall out. So that is all from my side, and if you have any question you can raise the question and ask me. Otherwise we have a dedicated website. Kindly go and visit our website. It is www.doj.gov.in, Department of Justice website. Under that you have access to Justice Division. You can go, and we have sub tabs where each program has the dedicated portal website. You can go and visit those websites. You can get the information. And let me tell you, dear students, we are trying our level best. We are trying, because we claim that we have touched the lives of 1 crore citizens. It is nothing in such million population, but at least we are trying to do the bit. And what we expect from you all, that start early and learn early. So after you pass out, you should have something with you that you can boast about. Okay, I know and I can contribute to the society. So thank you so much.
Okay, thank you very much, Dr. Sneha. Any question, query, participant? We can take maybe couple of questions before we start our second session. Yes, anyone? Yes, Nalini ma'am, you want to say something? You can unmute. We have not heard you for long. Nalini ma'am. Madam
No,
was
thank you.
director.
I'm just amazed.
Need,
Dr. Sneha is so right. Uh, all this information, well, definitely it's new to me. I'm just thinking how I can use this for right to education. And maybe I will go to Department
ma'am
of
was
Justice,
director in UPA in
what you've
Delhi.
told. Uh,
Ma'am, sorry to interrupt you. I have met you at NLU Cuttack in child right symposium in 2020. It's long
okay.
time. Yes, I have met you there. At that time, I was working with Child Rights Center at NLU Patna. So we have,
All right.
we have interacted also, and there is one WhatsApp group. There used to be one WhatsApp group where you used to post many things, and it was very, of informative for us. So we have met, but at that time it was a long year back.
Dr. Kalpesh has helped us form another group called Advocacy Group for
Okay,
RTE.
okay,
And in
okay,
fact, just today I was talking to one faculty member from one institute.
yeah,
They have collected information on right to education, in various schools.
yes, yes,
तो मैंने उसे कहा कि आप इसको publish क्यों नहीं करते? You have got evidence of violation of the child rights and child fundamental rights.
yeah.
She herself being a lawyer, a faculty member, she was scared कि how the government will take it that you are acting against the government. ये जो धारणाएं हैं, ये कहीं नहीं जाती. And these are law faculty dealing with fundamental rights of children. And
I understand, ma'am. I understand, ma'am.
people are scared of the kind of repercussions on them.
True, true, true. Very true. Very true.
How can this be done, through somebody, without their falling into this kind of problem? I'm just
Yeah.
thinking of those things.
Yes, yes, yes. Very rightly said.
So I met ma'am in one of the program at GNLU. So one
Mm.
faculty referred connected with ma'am, and they
Yeah.
shared with her your right to education. So
Yeah, she has
uh,
done marvelous job under RT, and we all know that. And personally, I have met her. If she might not be, remembering that we had a discussion also in that particular symposium
then
regarding
we
RT and how the lives of children has been impacted.
sure. Sure. And a few months back, ma'am, suggested, and then we plan out capacity building program or RTE.
Yes, yes,
So
very much
one
needed.
week program. So it
Yeah.
was a great, and many faculty member they were got a great insight on RT because we know fundamental rights, law is there. A lot of things. We have Mr. Susant also, our resource person. He also one of the resource person. So it's a great 1 week program. Again, initiated suggested by ma'am because I got to know because I cannot I'm into a variety of things. Right, we planned on human rights
No,
also
no, no.
RT. Then I also got to
You are doing really a very commendable job, and because of many constraints, we are not able to take you on board, Mr. Gupta. Really, every time, whenever I talk with my joint secretary, once or any time, there will be a discussion on you. But because of government policy, and there are so many factors associated, to take any private player. So those are sort of
yeah, sure.
occupational
No, no problem.
hazards we face,
No
but
problem.
but
I'm
we
just,
appreciate no, but we appreciate, and there is always your name, even in my colleagues also. मतलब, there will be, if something will happen, okay, उनका तो नहीं है, मतलब, there is always something, अच्छा ये वाली चीज इनकी ही होगी. So you have got that thing, and it's really very commendable.
the idea is that, just contribute wherever we are into whatever position.
Yeah,
So
yeah,
that
yeah.
is the
True,
idea.
true,
We have
true,
students
true.
from first year, like 12th
Yeah, yeah,
standard to,
yeah.
senior, like ma'am is there, other, Ruby ma'am is there, so that's the idea, like, make a difference wherever we are.
True,
So
true, true.
that's the
So,
idea, like,
yeah, and your internship
we,
programs are also very good. Students get associated, and get a good chance, to contribute in any form. They
yes,
contribute,
yes.
whether it's
And this
publication or
program,
anything. Yeah,
definitely, like, this fifth edition again, we are not planned, like, we planned first, second, third, and really, I'm getting uh, lot of many success story. I would say
yeah,
insights are
yeah.
there. People,
True, true,
all
true.
over the India, they are joined, and then because people are not aware about. Especially, let me tell, like, I invited you at Vadodara also in Paru University. I've been following Telelaw Nyaya Bandhu since beginning. So I keep
Yeah.
promoting. Okay, there is a
Yes,
helpline
yes, yes,
number,
yes,
these things.
yes,
But
yes. I
now
know.
I would say,
Because now we have now pro bono. People now know it is a Department of Government initiative. Initially, it was all about your pro bono. No, people get mistaken also. Ki, which one is which one's pro bono. So that is also
yes,
the
yes, yes.
thing. Yeah.
I remember I got a call in 2017 from Department of Justice. The call was for around 40 minutes. आप क्या करते हैं, कैसे करते हैं? But I
Yes.
was
Yes.
not aware of maybe for that, domain name.
Yeah.
So
Yeah.
because pro bono dash DOJ, that's
Yes. Yes. Yes.
uh,
Yes. That was the
separate.
thing.
That's a department.
Yeah.
URL is
Yeah.
there. But again, it came to my mind. I started. So
Nothing
small.
is like that. Yeah. 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 Pro bono word is no one can take the copyright. Is a pro bono word. Yeah.
Yeah, that's the things.
No,
Yes.
no one can take the
So
copyright over
yeah.
that. Okay.
One question we can take up, then we'll close.
Yeah, I can see
How
that
can a fresh
Ma'am Aditya has written, ma'am, how can a fresh law graduate can contribute? Because in DALSA there are a minimum. Okay, so you can join our program, join Nai Bandhu program, download the mobile application, and you can be on our panel, and you can contribute there. I can waive off this 3-year experience for you for Nai Bandhu, for what I can do in my capacity. You can register there.
Good evening, ma'am. Just one suggestion from my side. Raju
Yes.
is speaking.
Yeah.
Yeah, success of every program is dependent upon how we drive the program. So,
True,
for
true.
example, if you have been allocated targets have been allocated to for each and every program, definitely success will follow. Say, for example, Ministry of Finance had got a program earlier called 100% literacy program, and every bank has been mandated to have a financial literacy department under which we should form financial literacy centers and business correspondence, how many correspondents you have been brought into, like that. And we could achieve 100% financial literacy under the Ministry of Finance. Similarly, Ministry of Agriculture is also having some other programs like formation of Farmers Club, for which they will give some financial aid to such kind of farmers club program. Likewise, if Department of Justice Ministry and Ministry of Law and Justice could implement the scheme by giving some targets to taluk level service authority, or district level service authority, even we can make use of the bar associations attached to each and every court to have this much of outreach program. Then how many new programs you conducted, like that we can have some project.
Yes, yes, your opinion are very much appreciated, and we have also done from our side. We have done everything. We have had the MOU also with NALSA, where at taluk level also they were doing legal awareness program. But the thing is that it's all about money aspect is also there, and if you see the whole budget, how much money is given to justice sector, that is also one part of it. I don't want to comment right here, but yes, your opinions definitely, and suggestions I will be keeping in mind while framing the new MOU for the next financial year. I will definitely get that.
Okay, Mr. Raju Nair is a panel lawyer in a Kerala State Legal Service Authority.
Sir,
So
we already had the MOU and with SLSA, and every SLSA has the mandate to onboard the lawyers for telelaw program. We had that already.
Yes, ma'am, we will continue to support.
Okay, thank you so much. Thank you.
Manpower is not a problem here. We'll support as a pro
Yes.
bono services.
Yes, yes, definitely.
Thank you so much, ma'am.
Thank you.
we can take up last question from Nikhila Tigadi.
As an institution or individual, we can get associated with the pro bono. See, as an individual, if you are a lawyer, you can join the program and give the pro bono services. We have the mobile application. You can download the mobile application from Play Store with the name of Nyaya Bandhu. You can register yourself. As an institution, if you are the law school, see, right now we have taken the law school target as per our scheme for 2026. So after 2026, if there is a law school, they can call for the app. We generally publish call for the application for the law school. Under that, the law school can give their proposal. Otherwise, in pro bono capacity, you can attach yourself with this, what Mr. Kalpesh is doing right now. He has been attaching himself in the programs of GNLU Pro Bono Club. Likewise, if you want to be involved with the pro bono initiative, there are other law schools also. If I don't know you are from which place, if you can tell me you are from which place, Nikhila.
Hello, ma'am. Am I audible?
Yes, yes, yes.
Yes, I'm from Bangalore, ma'am, Karnataka.
Karnataka. So you are law student?
No, ma'am, I'm a law faculty.
Which college?
I am from Law School, Bengaluru.
Okay, so we can take the application from your law school when the openings come, because we have law school pro bono clubs in Bangalore also. We have a presidency with us, NLS Bangalore with us. Right now, there is one more new law school with us in Bangalore. So when the openings will be coming, I will be definitely intimate this to Mr. Kalpesh. So I must be he must be having the groups. He can circulate that circular in that particular group.
Sure,
Thank
ma'am,
you.
sure. Thank you
Thank
so
you.
much, ma'am.
Thank
Thank you. Thank you, sir.
I think we can close. Mr. Sushant has joined. So thank you very much, Dr. Sneha, for sparing valuable time at a very short notice. Again, it was not planned, but again,
No
because
issues.
you are
No
having
issues.
you
Yeah,
are
yeah. We are
having double
also pro bono. Don't
responsibility.
worry. Don't worry. We are here. And happy Women's
You are,
Day to all the wonderful women out there.
thank you very much. You're having double
Okay.
responsibility at home, so I didn't want to disturb you, but again, I requested you, and then you readily agreed. So on behalf of organizing committee, I am grateful for your sparing wonderful time, and look forward to seeing future events also. Thank you very much.
Hmm?
Thank you.
बाहर तक गाड़ी तो
Yes, Mr. Sushant, are you there?
Hi, Kalpesh, how are you? I'm
हेलो, हाँ,
audible?
no, थैंक यू फॉर ज्वाइनिंग, सॉरी, थोड़ा आगे चले गया सेशन।
Not a problem at all.
श्योर
Not a
श्योर,
problem.
थैंक यू, आई थिंक वी कैन स्टार्ट, यस, युवराज,
I'm
ओवर टू यू।
grateful to you, on the contrary, for accommodating my request for shifting my session over the weekend.
नो नो नो, थैंक यू, यस, युवराज, ओवर टू यू।
Good evening, sir.
Hi.
So, sir, can I start the meeting?
Of course, please go ahead. Sure, we can start.
Public interest litigation (PIL) is a constitutional remedy that empowers citizens to seek justice for the greater good. Rooted in the principles of social justice and equality, PIL provides a framework for challenging government actions policies that infringe on fundamental rights. This conceptual framework is built on the pillars of locus standi, judicial activism, and the expansion of fundamental rights. First of all, welcome, sir, on the behalf of Pro Bono India and Pro Bono Club GNLU. It is my pleasure to introduce Mr. Sushant Chandra, a distinguished lawyer and educator who will be joining us today for this online session. With an impressive academic background, including a BA LLB from GNLU and a BCL from the University of Oxford, Mr. Chandra has established himself as a leading expert in commercial litigation and white-collar crimes. As an adjunct faculty member at the Jindal Global Law School, he has taught courses on public law and legal philosophy, and is also a part of subcommittee working on introducing access to education and legal aid curriculum in law schools across all over India. We are honored to have him share his insights and expertise with us today. Over to you, sir.
Thank you so very much for that kind introduction. Um, the topic which has been given to me is a complicated topic, and I will try to do justice with this topic in the little time that I've been given. I would also try to take as many questions as possible around this topic. Before I proceed with my content of my lecture, can you briefly tell me what exactly, I mean, how do we have mostly lawyers or do we have mostly law students as part of this cohort, which would help me in
Yes, sir. We have a law student. We have 12 past students also. They'll be joining law school after few months. So that range from faculty member, professional also, and there are some people from non-law background also.
fantastic, fantastic. Thank you so much, Mr. Kapil. So, all right. So, when we speak about conceptual framework of public interest litigation in India, there are certain fundamental questions which come to my mind when I think about PIL. I'm sure the previous sessions must have covered some of these topics, and at the cost of reiteration, I would again visit them with the hope that I would be able to expand a little more on them. So, when we say public interest litigation, what do we mean by public interest litigation? Philosophically, trying to understand that, and what exactly is the need for public interest litigation? Now, for non-lawyers and the ones who would be going to the law school, PILs were created with an intent to make access to the courts possible for people who come from marginalized sections and disadvantaged group categories. So people who do not have their voices being heard, naturally, they could approach the courts of law via media. Now, when I say via media, I mean that any public spirited individual could knock at the door of the court and can make the plights of people who belong to marginalized communities be heard before the court. Now, this could be done by way of writing letters to the Chief Justice. This could be done by way of writing letters to the concerned bench, which has the roster of hearing public interest litigations. And there are multiple such examples. I have tried some of these methods before successfully before the court by writing simply letters to the Chief Justice. And trust me, just because one or two occasions you do not get response from the court, that doesn't mean that they do not hear you. The epistolary jurisdiction of the court works very, very well. So that's one way of going about it. Other way of going about it is by simply filing a petition before the court, which you already know that by filing a writ petition, that's normally what we call it as, before a constitutional court and before the Supreme Court, the High Court and the Supreme Court. Now, one very interesting observation at this point of time that I would like to make here is, I'm sure most of you must have watched this movie Jolly LLB, and you must have seen in Jolly LLB, they say public interest litigation was being filed before the Sessions Court and not before the High Court or the Supreme Court. It's a very interesting observation, especially when the structure of the PIL seems to be a dynamic structure in the country. Now, most of you would be observing that it's a bizarre situation that PILs cannot be filed before the Sessions Court. And you're absolutely right. PILs cannot be filed before Sessions Court because PILs are being read under the writ jurisdiction within the Indian Constitution, which is Article 226 and 32 of the Constitution. Now, then the question would be, can't PILs be filed before the Sessions Court? In India, you can't. But let me tell you, at this point of time, there are very interesting examples across the globe where access to justice in the form of public interest petitions could be filed before any court and not only before a constitutional court. Can you guess which country? Anyone? Where instruments similar to PILs could be filed before any court. Before any
Australia?
court.
Australia?
No, not Australia. It's Colombia. Colombia has one very interesting mechanism which is called as tutela. Now, tutela remedy is like PIL remedy, wherein access to certain rights could be mentioned before any court in Colombia. And very interestingly, unlike Sessions Court in India, any of the courts in Colombia have the power to punish the executive for not complying with that order under the contempt jurisdiction. It's a very interesting, very fascinating fact. Now, moving a little further from there, coming to the structural framework of public interest litigation in our country, as I said, PILs are being located within Article 226 and Article 32 of the Constitution. And if you read Article 226 and Article 32 of the Constitution, there are certain writs which have been mentioned under Article 226 and 32, which are basically 5 in number. Now, very interestingly, you will find that the writs which are mentioned in Article 226 and Article 32, which are 5 in number, is not an exhaustive list of the remedies that you could seek from a constitutional court under a public interest litigation. What do I mean? Does it mean that we have more writs? The answer would be yes. If you read Article 226, Article 226 is in the nature of, the writs is in the nature of inclusive list. It is not an exhaustive list. So, just to give a very small example, you must have heard about many a times petitions are being filed, PILs are being filed before a court seeking SIT investigations or CBI investigations to be conducted in certain scams, in certain matters. And some public spirited individual would file a petition before a court saying that we have come across certain instances wherein certain scams are being conducted, and you want the court to conduct a CBI investigation into this. This few years back, you will find newspapers replete with these kinds of news headlines. Now, this was something which was created in 1990s itself, where the Supreme Court, in one of the cases where one reporter filed a petition before a court with respect to Jain Hawala matter, which was going on, and then he sought a remedy of CBI investigation, wherein CBI was requested to report on a frequent basis before the court. But this was not done before this petition. And then the court, while interpreting this, said that the remedies which is being mentioned in the form of the writ is not confined to those five. It's inclusive in nature. And then the court said, no, there's something this court is continuous mandamus. So when we speak about the public interest litigations, and when we speak about the writ jurisdiction under which public interest litigation is to be situated, the writs that you could seek in public interest litigation is identical that you find under Article 226 to 22, and it's not exhaustive in nature, it's inclusive in nature. Courts have the liberty to craft and design the remedies that you wish to avail from the court. Now, moving a little further from there, which provision within the framework of the Indian Constitution is mostly invoked when we file a public interest litigation before the court? Now, Article 21 in that context is a very, very fascinating provision. If you read Article 21 provides for a liberty clause. It says no one shall be deprived, no person shall be deprived of one's life and personal liberty except in accordance with the procedure established by. If you look at the language of Article 21, and trust me, more than 90% of the PILs which are being filed would use Article 21. Post Manika Gandhi, of course, they would use the other articles too, 14, 19, and the other provisions. But Article 21 seems to be the kernel in claiming enforcement of whatever you seek from a constitutional court. Article 21's understanding becomes imperative here. If you look at the textual arrangement of words in Article 21, we say Article 21 safeguards, which is very popularly called as negative liberty. I'm sure the ones who might be practicing and the ones who might be teaching would, of course, be very, very well aware of the term negative liberty. But for the ones who are still in the law school and the ones who will be joining the law school, allow me to elaborate on this briefly. The term negative liberty under Article 21 states that I, as an individual, am allowed to exercise my freedom unless and until I am not affecting someone else's freedom, and the state has not prescribed a mechanism by which I am doing something which should not be done. Now, just to give you a very small example, I engage in some wrongful act. Say, for example, I've been siphoning money, and because of siphoning of money, the investigating agency comes and attaches my property. Now, what is happening here? My liberty is being deprived and detained here, which is in the form of my property. And this is being done by the investigating agency by way of attaching my property. So what is happening? Can they do so? They can do so because it is something which is being prescribed in the procedure established. If it is not being prescribed in the procedure established by law, they cannot do it. What does that mean? Say, for example, I have not complied with some bylaw or rule of the local development authority, and because of which the local development authority issues notice to me, which should at least give me an opportunity of responding to the authority within 30 days. What they do, they come, they serve notice upon me today, and tomorrow they come and they say, we are going to demolish your house. Can they do so? They cannot do so because that is not the procedure established by law. So this is the kind of liberty. If I am going to be arrested, I am going to be arrested in accordance with law. If my property is going to be taken, it has to be taken in accordance with law. If it is not given in law, you cannot take away my liberty, you cannot take away my property, you cannot play with my freedom whatsoever. It's in that context Article 21 is being worded. If you look at Article 21, that no person shall be deprived of his life and personal liberty except in accordance with the procedure established by. Now let's look at some of the claims which have been brought before the court and where Article 21 has been claimed. Now, since we are talking about legal aid mostly, what about right to engage a lawyer, which is given, pre-legal aid is given under DPSPs, Directive Principles of State Policy. Directive Principles of State Policy are not judicially enforceable, and they would require a certain budgetary allocation to be made by the government. As Sneha ji was here before me, they have been doing a commendable job, but that requires allocation of budget on the part of the ministries. Article 21's language talks about negative liberty, but within Article 21, can you claim I should be given a lawyer to defend myself in a court of law? Let's take that as one example. What about your right to food? We know that how the PDA system works in the country, and it was a great law that was enacted in 2013 in the form of National Food Security Act. But there's a huge history to it, which was in the form of public interest litigation. And again, Article 21 was very significantly used in that public interest litigation as well. What about right to education? We now have Right of Children to Free and Compulsory Education Act 2009, but for the longest time, this law was not there. And what about the claims which were being brought before the court of law, the High Court and the Supreme Court in the form of PILs with respect to access to education? It is given in DPSPs, you are right. But in the form of fundamental rights, where would you situate that? The same thing would go for access to healthcare as well. Critical healthcare, non-critical healthcare, IPDs, OPDs, critical diseases, free medicines, surgeries. It's given in DPSP, but where would you locate that within the framework of the fundamental rights? Now, it's at this juncture, it becomes relevant to say that, can I claim DPSPs independently of invoking any of the fundamental rights? Because we see that Article 21, which is what I'm going to argue in due course of time, appears to be the kernel provision behind claims pertaining to public interest litigations, does not in its language permit these kinds of positive claims to be made before the courts. Because as I said some time back, Article 21 provides for negative liberty. Negative liberty means that my liberty, my freedom will not be interfered with by any executive, by any state government, unless and until there is a due process of law. There's a procedure established by law which provides for taking it away. Otherwise, you cannot tamper with that. The demolition example, remember. So now it's interesting that most of these public interest litigations, when we speak about the conceptual framework of these petitions, they could be split into parts. One is which pertains to civil and political liberties, which would talk about undue or unjust encroachment or intervention by the executive in your liberties. And second would be asking for certain additional claims from the executive, which executive should provide to us, be it in the form of medicines or healthcare or education or access to justice. Now, we have already seen that the language of Article 21 it's couched in negative liberty contexts. The Supreme Court, interestingly, in 1980 was experimenting with this, and they located these positive claims too within the framework of Article 20. So where do you locate these positive claims? These positive claims are being located within the framework of Article 21, mostly. And of course, in other provisions too, including Article 14 and Article 19 as well. Now, when we say Article 21, how do you think Supreme Court locates it? Under Article 21, when the language of Article 21 itself is couched in a way wherein it only secures undue or unjust encroachment by the executive in your freedom, and not claiming certain additional benefits from these things. Would anyone like to respond to this? Because I've already said earlier that DPSP standalone do not exist. Merely if you go to the court of law and say, look, I want to enforce my Article 44, 45, 39A, the court would junk your petition outright. They would say, no, this is not maintainable. Haven't you read the starting provision in Part 4, which says that these principles are fundamental but not justiciable? So, anyone? Any responses to this? No responses. All right, that's fine. So when we look at Article 21 in 1980, the court was experimenting with trying to strike a balance between the claims which were safeguarded in the form of principles enunciated in Part 4 of the Constitution with the fundamental rights of the people. Maybe at the time of the commencement of the Constitution, the budgetary resources or allocation may not have been made, which appears to be one of the reasons why most of these, not all, but most of these socioeconomic claims were being put in Part 4. But slowly and gradually, the court started realizing that maybe we can engage more with the executive on this. And maybe we can see how to make executive answerable to us to ensure that these claims which are being brought before us in these public interest litigations should be provided to these people who are coming before. And then the court started experimenting with Article 20. And court said Article 21's language is not to be interpreted stricto sensu. It's not to be seen in a very literal way, in not very textual way. We have scope of expanding Article 20. And when they said they had scope of expanding Article 21, which is one of the settled principles as to how the Constitution should be interpreted, it's a living field of truth. That Constitution should be interpreted in accordance with the needs of the society at that point in time. And the court started exploring how do we connect Article 21 with Part 4 of the Constitution. And it's at this point the court started exploring how should we reason it out that whatever claims are being brought before us under Article 226 and 22 in the form of PILs, be it in the form of food or healthcare, we could provide it to the people. And some of these principles, which if you skim through some of these judgments in the court in 80s and 90s, you will find that one very, very beautiful principle which court has been experimenting with, and I find it intriguing that the content of this principle is not settled. And when I say principle, courts have used it beyond its usage as a principle. This is the concept of dignity. Dignity is izzat. There was one Jackie Shroff movie I remember when Jackie Shroff used to say, izzat se jeena, izzat se marna, izzat nahi to kya jeena marna. So court has been using the concept of dignity as a principle, as a policy, as a right, as a constitutional value, as a constitutional goal in expanding on the contours of Article 20. So many a times you will find that when the litigant goes before the court and says that, very interestingly, look at the example of Pandit Parmanand Katara's case. Most of you must be aware of Pandit Parmanand Katara's case. It was a PIL that was being filed in the Supreme Court in 1989 with respect to road accidents, medical legal cases. And one individual had met an accident, and this individual was taken to a nearby hospital. The nearby hospital said that, look, we cannot admit you because medical legal cases are not being treated here. There's a specialized facility to treat medical legal cases, which is 20 kilometers away from this facility. So you are required to go there to that facility and get yourself treated. And this fellow was taken to that facility, and on way, the poor chap succumbed and he passed away. And then one public spirited individual filed this public interest litigation before the court on the newspaper cutting, saying that what is going to happen to people? I mean, because of someone's negligence, are people going to die? And then the Supreme Court used briefly the concept of dignity and tried to fill the concept of dignity with the oath that doctors take. The court said that, look, in your oath, you say that you will not discriminate any patient who's going to come to you and you will treat them. And now you cannot simply say that because of it being a medical legal case, you're not going to treat them. And then the court issued slurry of directions after that, saying that in cases of medical legal cases, the emergency cases must be treated immediately by the doctors who are on duty. You cannot simply wait for the police to come and report to be lodged before the police for the patients to be treated. Now, this is one of the examples where you will find the concept of dignity was being filled with the oath which is being taken by the doctor. Few years later, you'll find another very interesting case which comes to the Supreme Court, which was in the form of Paschim Banga Mazdoor Khet Samiti's case. In Paschim Banga Mazdoor Khet Samiti's case, Supreme Court, where one individual who fell from a train and had several head injuries was taken to several hospitals. I believe some 5-6 hospitals he was taken to, and still all the hospitals refused admitting this chap, saying that we do not have the facility, doctor is not available, medicine is not available, so on and so forth. Finally, this chap was taken to some private facility where he was treated, and some 16,000-17,000 rupees was incurred on his treatment. And after his treatment, the Mazdoor Association to whom he belonged to filed a case before the court. The matter reaches the Supreme Court. Supreme Court was asked to adjudicate on this with respect to deficiency of services by the government hospitals and whether the services being rendered by doctors would be counted as services or not, and whether this individual could be called as a consumer or not. And then the court again expanding on Article 21. I've told you Article 21 is couched in negative liberty context, but court says Article 21 also subsumes in itself healthcare as well of any individual. And it's incumbent duty of the government hospitals to provide for it. And court sets up a committee, and court asks this committee to come up with certain recommendations. Multiple recommendations were being made pan-India, but most of these recommendations not been complied with even till date. This is one of the examples where you will find that the language of Article 21 does not confine the remedy which is being sought by a via media before a court of law. Court has expanded Article 21, but has the court been superficial in expanding Article 21 without providing any legal reasoning whatsoever? Many people to whom I ask this question, and many people with whom I have this discussion, they say courts have been erratic. It's more like anyone who comes to the court, if you have a good judge, you will find the indulgence of the court in those kinds of cases. But there doesn't seem to be any legal reasoning which appears to be flowing when the court seems to be expanding the jurisprudence around public interest litigation, which is not true, actually. I gave you 2 examples. I could give you more examples on this. Let me give you an example of People's Union for Civil Liberty, a case that was being filed in 2000, I believe, 1 for the first time, wherein food, grains, which were in the warehouses in some place in the outskirts of Jaipur, were rotting, and a lot of people who were living in that vicinity, they were dying out of poverty, and PUCL could not see. PUCL filed a petition before the Supreme Court, and the Supreme Court, while hearing this matter, expanded this, not only confining it to the city of Rajasthan or the city of Jaipur or the state of Rajasthan, but I believe the Chief Justice of India at that point of time was Chief Justice B.N. Kirpal, who asked the councils for the PUCL to impede the other states too in this and ensure that the food grains which are being wasted in the warehouses of different states are being distributed to people who are in need of it. And this and it's a very interesting PI. Those of you who want to actually see how interesting any PI would be, this is as interesting as it can be, you will find that multiple dozens of orders being passed in this case, months after month. Many a times courts would say, Chief Secretary is not impleaded of one state, you please implead them. Notice is not being served upon them. Some other fellow would come, they would ask to get impleaded in that petition. They would say the same issue is happening here, and the court would pass slurry objections, one after the other. Whenever the petition was being heard, they would scold the secretaries concerned. They would say that, look, we want people not to go hungry to bed. We want to ensure that people get food. And this was being done within the contours of Article 20. Court said no, liberty does not mean only negative liberty, it also means positive liberty. Positive liberty casts an obligation on the state to make budgetary allocation for providing all those essential facilities which are quintessential for a dignified life. And you see what was the culmination of this? This public interest litigation led singularly to enactment of National Food Securities Act of 2020, under which the PDS and the midday meal scheme and the other schemes that we know of, which are functioning very well in so many parts of the country, are being situated. So you will find umpteen examples wherein PILs were being filed, Article 21 was being expanded, and dignity was used as a legal reason in expanding the contours of Article 20. Now, this is not only with respect to expansion of Article 21. There's one additional point I believe I might have missed out on before, which I want to again go back to, which is in the context of the relief or the remedy that would be given in the PILs. Now, I was trying to figure out the answer to this question myself, and I thought I should pose this question to you before I delve any deeper in this question, which is, do you think can you seek a mandamus from a court in a PIL to get a law enacted on a certain issue? Any law students could answer this question for me. When we say that PILs are there, we think that the courts have enormous powers in PILs to do anything. And I gave you an example wherein one very popular PIL led to enactment of a law. But the question is, let me put a counterfactual here. Would the councils in PUCL case have claimed for enactment of National Food Securities Act in that PIL? And this is where we come to the conceptual limitation of the public interest litigation. So one of the limitations of public interest litigation is that you will have to, as a court, I mean, and as a litigant, I mean, have to respect the principle of separation of power. When you seek an order from a court, requesting the court to direct the legislature to enact a law that is clearly in violation of the principles of separation of power, because it is the job of the legislature to enact a law. And this is not judiciary's business to tell which law should be enacted or what amendment should be brought in. But very interestingly, if I again introduce another counterfactual to this, which is, can you seek a mandamus from a court directing the executive or legislature to contemplate if a certain law should be enacted or not? The answer to this question perhaps may be in affirmative. You can seek a direction from the court if the executive thinks it's the right time to enact a law on access to healthcare or not. And then the executive can respond to the judiciary saying that, sir, we cannot enact a law on this point because we do not have the resources, we do not have the infrastructure, whatever. But this would not be considered to be as violation of the principle of separation of powers, because you're not directing the executive or the legislature to enact a law, but you are simply asking them if they want to do it or not with whatever information they have. Now, this kind of interaction, healthy interaction between the executive and the judiciary, is found in some other jurisdictions too. This is called as the weak form of judicial review. In weak form of judicial review, the judiciary does not direct the executive to do any act, but simply asks them if they want to do it or not. And then the executive responds by way of filing an affidavit before a court telling what they would like to do with respect to it. Of course, this healthy dialogical debate between the executive and judiciary helps both the wings of the government in arriving at a healthy, conclusive decision. Some countries also follow what we refer to as strong form of judicial. In strong form of judicial review, the judiciary directs the executive to do a particular act. Now, I've told you a strong form of judicial review and weak form of judicial review. The question would be, what is it that we follow here in our country? Do we follow strong form of judicial review or weak form of judicial review? Any responses to that? Would anyone like to respond to this? No responses? All right. So there doesn't seem to be in straight jacket. All right, I'll wait.
Okay, participant, please respond, interact. Otherwise, it will be boring. Any concern, query? This is again, we learn practical thing. Again, the session was previously planned before practical thing. Yes, any input from your side?
I again repeat
Faculty
the question.
members,
The question
student.
is, do we follow strong form of judicial review or weak form of judicial review? In strong form of judicial review, when the policy or legislation does not provide for something, the court can direct the executive to provide for. In weak form of judicial review, court cannot direct, but court can simply ask if the executive would like to provide for that. We have one response, I believe. Cecil G says it's weak form of judicial. So the answer seems to be correct. Cecil G is right. We follow a weak form of judicial review. There's a wonderful paper which was written some time back. Perhaps I can show this for the participants too. In that paper, it was being argued that where the executive does not provide for any benefit, the court will not engage in a PIL to enforce it. Example, if a certain government circular provides that up to 10 lakh rupees medical healthcare facility would be given to individuals who come from marginalized community, and one individual who comes from marginalized community incurs an expenditure up to 7 lakh rupees and the state does not reimburse it, then this individual can go before a court of law for himself and ask that the executive should reimburse his 7 lakh rupees because the policy provides for reimbursement up to 10 lakh rupees. What if this policy was not there and still the individual could have incurred an expenditure of 7 lakh rupees on his health from any government facility or private facility for that matter. In that case, the court would have not directed the executive to reimburse. This is weak form of judicial review. In strong form, the court would have directed, but in India, the courts would not direct what you will find. There have been some glaring, brilliant examples wherein the courts have engaged in that. One such example which comes to my mind, and I would, before concluding this session, come to that part, and then we can open this to the others. I'll summarize this as well before I conclude it, is the case of Muhammad Ahmad versus NCT of Delhi, 2014 judgment of the Delhi High Court. In that judgment, one individual, a child basically, was suffering from one disease called as lysosomal disorder. And this lysosomal disorder is a disease wherein fat gets deposited on the organs of the individual, ultimately leading to the death of the individual. And there is no cure of this disease. There is only an injection which comes from a big pharmaceutical company, which costs a lot, I believe from 5-6 lakh rupees a month, which is to be given for a long period, and then possibly one could be cured, one may not be. There's no certainty of cure. It's a rare disease. A PIL was being filed before the court, seeking direction from the Delhi High Court to the executive to reimburse the expenses incurred in the treatment of this child who was suffering from lysosomal disorder. Now, as we were discussing some time back, India follows weak form of judicial review. In the absence of any policy on rare diseases, courts should ideally wouldn't have directed the executive to provide for any sort of reimbursement or provide for any sort of facility because there's no such policy available. South Africa, weak form of judicial review, right? Very interestingly, Delhi High Court carves out a remedy saying that on moral grounds, reading the principle of substantive equality under Article 21. So far, we have seen the principle of dignity was being read under Article 21. Court is now reading principle of substantive equality under Article 20. Principle of substantive equality, you would remember, is the same principle which permits for affirmative action in the country. That those who belong to marginalized communities, who have been historically prejudiced, should be given a certain benefit to come up on the ladder. So court here says that people who belong to a certain community, people who are poor, people who belong to certain sections, vulnerable sections of society, they should be given a preferential treatment by the government with respect to access to healthcare in this public interest litigation. And court now expands Article 21 not with dignity, but with substantive equality. A principle of Article 14 is now being read under Article 21 of the Constitution very interestingly. To me, it seemed fascinating because post Maneka Gandhi, we have seen Golden Triangle principle, but I saw this, perhaps I may have missed it in the past, but to me, this was the first occurrence of its kind wherein the substantive equality was used as a legal reasoning in conceptually expanding the contours of remedies under Article 21 of the Constitution, because previously it was being done only by using the principle, goal, right, value, policy of dignity and not substantive equality. So, just to summarize whatever I said in this session, I talked about the public interest litigation, providing for ensuring access to justice for vulnerable communities before the court. I said that one is not required to establish one's locus before the court. It could be done via media. Some individual who's a bona fide could be proven before the court of law, could come to the court of law and seek remedies for the people from vulnerable sections. I also spoke about Article 226, Article 32 of the Constitution. I talked about how Article 32 and Article 226 inheres in it the concept of public interest litigation. I also talked about how the different kinds of writs under Article 226 and 32 are not exhaustive in nature, but inclusive in nature. I gave you the example of Jain Hawala case. I told you how continuous mandamus was being used by the court in continuous probing by the CBI in that case. Then I talked about the Article 21's content. I talked about how Article 21 in its original pursuit only talked about negative liberty. I said how 1980s courts started expanding Article 21 and also interpreting Article 21 to not only mean negative liberty, but also to include positive liberty. And positive liberty was being used to connect Article 21 with the claims under DPSPs. I then talked about how the constitutional principle of dignity was being used by the courts in 1980s and 1990s in expanding the contour of positive liberty under Article 21 in providing for the claims relating to positive claims such as healthcare, access to justice, education, and so on and so forth. Then I gave you a few examples in the form of Pandit Parmanand Katara, Paschim Bangal Mazdoor Ek Samiti, PUCL versus Union of India, when I spoke about how the concept of dignity was being expanded by the court. And though the content may not be absolutely certain, but the courts have been clear in terms of using the concept of dignity under Article 21. Then I spoke about some examples for some comparative literature in the form of weak form of judicial review, strong form of judicial review. We talked about how India follows mostly the weak form of judicial review, but there doesn't seem to be an absolute rigid compliance of that principle. To establish the exception to that, I spoke about Muhammad Ahmad Khan's case, when I talked about how the court, even in the absence of a policy or any government order or circular, still gave remedy to the individual, tried to craft it on the moral grounds of situating the principle of substantive equality within the framework of Article 21 of the Constitution. So, I mean, this is the summary of what I said. I'm opening the floor for anyone of you who wants to raise a question, ask a question, seek a clarification. I will be more than happy to respond.
Participants, you can ask your questions right now, or you can mark your question in chat box. Sir will answer.
Yes, any question, query, participant, you can share, or maybe your inputs, concern, you also can share.
No, I would like to believe that everyone is asking questions, but they are muted. Please unmute yourselves and ask your question.
Yes,
Yeah,
good evening, sir.
yes.
Yes, good evening, sir. There's one question from my side.
Hi, Mr. Nair, please go ahead.
Yes, is there any requirement of a PAL to be filed before any court? Because nowadays in Kerala we find a lot of queue for buying stamp papers, and that too in front of high courts. And why can't the high court, instead of waiting for a PAL, why can't they file a suo moto case in such cases? Because they are waiting for 3 hours time, and then after 5 o'clock that vendor will shut down and they go away.
That's a very relevant question, Mr. Nair. The problem, one, I could not reach that point. I mean, two additional points if I can address. One is with respect responding to your question, which is there doesn't seem to be a specific SOP in terms of making PILs accessible to everyone. And that is where your question is essentially coming from. When you say that the audience which is intended to be the beneficiary of the PILs is vulnerable section, then how do you make the court procedures simpler for them? I give you one small example. Some time back, when the COVID was going on with respect to fee in the private schools, I wrote a letter petition to the Chief Justice. The letter petition was converted into a public interest litigation, and the same was posted on board for hearing. a division bench by one of the judge who is now in the Supreme Court, he was hearing this petition and he said, Mr. Counsel, you will have to convert this letter petition into a proper petition. So I said, my lords may exempt this. My lords may, on the basis of whatever content is there in my letter, may issue notices to the other sides. He said, no, we are required to follow the procedure of the High Court rules. You are required to comply with that. So, Mr. Nair, your question, to respond to your question, there doesn't seem to be a standard national uniform SOP in terms of how do we make PILs accessible to the intended beneficiaries. Unless and until that happens, we know how the judiciary functions. Judges would be trapped within the procedural rules which are being prescribed by the respective high courts, and unfortunately we'll have to comply with the stamp rules unless and until that that uniform SOP is being created.
Thank you so much,
Have I
sir.
responded to you, Mr. Nair?
Yes, sir. Thank you so much.
All right. Someone has
Sir,
spoken.
there is a question in the chat
Yeah.
box from Mohammed
Yeah.
Faisal Nawaz.
Yeah. Faisal, can you please explain this question? I'm unable to get what exactly you're trying to ask through this question. Can you speak up?
Yes, Mohammed Faisal. There are two questions from Mohammed Faisal.
I get Faisal's question. I'm so glad he asked this question because when Mr. Nair asked that question, I said I had two other responses to make. One was with respect to his question. Second is with respect to Mr. Faisal's question. Uh, Faisal, if I'm getting you right, you mean that despite the directions being made by the court in its order, it's not being implemented. Am I right? At the grassroots? Am I right?
Can you please repeat, sir?
हाँ मैं ये कह रहा हूँ कि despite getting a favorable order from a court of law, you are unable to get the same implemented at the grassroots level. Is that what you are trying to ask?
Yes.
Yes, it's a very, very good question. That's a wonderful question, actually. Perhaps one question which goes exactly at the very root of public interest litigations, which is the study on Kalpesh Bhai can perhaps ask someone who's academically working on this area, is the absence of any document on how the courts have been going about ensuring the implementation of these directions which are being issued in the PILs, because there is no study till date which discusses the contempt applications which are being filed pursuant to these PILs. So the courts passes great orders in PILs. The names of judges comes on front pages of newspapers. But if you see few months down the line, what is happening with respect to the implementation of these directions, you will find that in 9 out of 10 cases, what Faisal is saying is correct, which is that these directions are not being complied with. And the reason for that is contempt applications are not being filed. Now the question is, if a via media or a third party was filing a petition before a court of law for benefiting a vulnerable community, then should that individual also bear upon himself or herself to file a contempt application to before a court of law? If the answer is yes, that's an unnecessary burden. If the answer is no, then what about the implementation of these guidelines or directions being issued by the court themselves? So it's high time now that we go beyond the directions of the courts and also look at the status of the implementation of these directions by the constitutional courts by exploring how content applications are being decided by these constitutional courts. Faisal, have I responded to you?
Yes, sir. Yes, sir. Thank you, sir.
What is the odds of PIL being successful in Supreme Court?
Sorry, I'd like to add one thing. Like MC Mehta, like he's still following that case. 1987. Still right now, things are happening. Same case I can citation 87 following up with Supreme Court. What happened like in years back? Tartepesium, and then so many cases, MC Mehta filed. So things are happening. So follow up is necessary, and he has been doing that. Recently I saw felling of the trees in UP. That act is there, and so again I could see, because we are preparing case compilation. So I was searching and then see 1987 still he has been following up that particular case. This guidelines was given, and then so things are there. Yeah. Over to you.
No, one example which I remember a few years back when Swami Agnivesh was alive. Swami Agnivesh was sharing with me his experience of filing a PIL in the Supreme Court. I would not name the counsels, I would not name the judges involved in this. So he said he was working on the bonded laborers in the queries of Haryana. And it was being filed by one of the veteran academics, being heard by one of the celebrated judges of the country. And great order was being passed in that petition with respect to bonded laborers. But when it came to the implementation of this, he said, and this was a few years back before he passed away, he said uh, he tried to ensure the implementation of those guidelines, like Faisal said some time back, but he could not get it done, unfortunately. So this is a sorry state of affairs in terms of the implementation of the orders of the court from the constitutional courts. Odds of PIL being successful in Supreme Court. Uh, I mean, two takes here on Mr. Kanan. One is you craft your PIL in a way wherein you could show violation of a right in the most strong way before a court of law, especially in the Supreme Court, because that's the apex court, final court to decide a case. Second, be strategic in terms of filing a petition. See to it whether a public interest litigation would fetch you a better remedy, or whether an adversarial petition would fetch you a better remedy. If you think that filing of an adversarial petition would fetch you a better remedy and you would be able to get the directions which possibly you could have got in a PIL, it's advisable to go with adversarial petition. So see, be strategic about filing of the petition, show the violation of a right in the most strongest way possible before the apex court. Of course, you'll be successful. Any other question?
Okay, any other question, participant, or we can close? So one
Yes,
question of my
one question I wanted to ask.
yes, Kanika.
Right to personal liberty and living with dignity. Sir, dignity, that Aruna case, I wanted to ask that right to die and right to live with dignity. So is there any public interest litigation in this case also? Aruna's case, where she was very sick.
Kanika,
A person to live with dignity, sir. I mean, a person cannot live his life, is being very sick. So what can be done in that case?
There are two takes on that, Kanika. One is the constitutional take. Second could be my opinion on this. As far as the constitutional case is concerned, I believe courts have allowed passive euthanasia already in this country.
Yeah.
Passive euthanasia is permissible in law. Few years back, Supreme Court's constitutional bench permitted passive euthanasia. As far as active euthanasia is concerned, now, which is where I think my opinion I would like to give, is, I mean, we as an executive, we need to be absolutely certain of ensuring that there is no misuse of the provision for active euthanasia. And there needs to be a lot of brainstorming around that, because there possibly could be a misuse of active euthanasia as well.
Okay.
So it's not possible to respond to this question in 2 lines or 3 lines. I believe this requires a lot of brainstorming on the part of different stakeholders, especially the medical practitioners, as to how do we go about ensuring that the genuine cases wherein an individual uh, who's willing to quit one life uh, uh, because of health reasons or otherwise is medically approved or permitted. and how would you go about ensuring that there is no misuse of it is the biggest question which comes to my mind when I think about active youth in this year. But we can have a chat around this. I mean,
Yeah, yeah, definitely, sir. Thank you.
Any further questions?
I think done with the questions. Over to you, Raj. Yeah.
Thank you, sir, for the lecture. And I would like to take a moment to express our heartfelt gratitude to our esteemed speaker for shedding light on conceptual framework of public interest litigation. Your insightful lecture has inspired us to think critically about the importance of PIL in promoting social justice and protecting the rights of marginalized communities. We appreciate the time and effort you took to share your expertise with us, and your passion for the subject is truly commendable. Your lecture has been valuable addition to our understanding of the topic, and we grateful for your contribution. Thanks also a thank to Kalpesh sir and Hardik Parekh sir for organizing such a wonderful session. And also I would like to thank all the participants for their attentive participation throughout the lecture. Thank you.
Thank you, Kalpesh Bhai. Thank you, Yuvraj.
Thank you. Thank you.
I'll share my email ID just in case if anyone wants to carry forward this conversation. I'd be happy to respond over mail to anyone.
Sure.
And we can have this conversation going on over the weekends. May not be possible over the weekdays, but over the weekend, I promise to respond.
Sure, sir. Okay. Thank you very much.
Thank you, sir.
Thank you, Yuvraj, and thank you, participant, for joining. See you tomorrow at 11 a.m. So, it's being a Sunday, so we have planned in the morning. Thank you very much.
Any trial exam, sir, also? Some screening exam?